I think
Right.
that's one of the worst things I can imagine is my parents on their
Right.
deathbed and I'm the one deciding whether they live or die. It's like a godsend to say that here's a document in their own words.
Yeah.
No matter what me and the siblings and the family thinks, look,
Yeah.
this is the order.
Yeah.
And I'm not the decision maker. Welcome back. I'm excited to be joined today by Danielle Palm, an attorney who's been practicing for over 20 years. And I'm excited to talk to her about the most common question that she gets from her clients. What documents are part of that basic estate planning package to make sure,
Yeah.
hey, I've got my card checked. Here's what I need to know to make sure everything's running.
There's going to be 5 things, I'll call them categories, that I talk to people about. The first item on my list, which is the will trust vehicle. Like these are the dead documents. And this is where we're really coming up with our dispositive plan of what we want to have happen to our assets. But really, it's our dead plan, right?
Sure.
It's the plan for what we want to have happen to our children, to our money, to our assets, and then who we want to be in charge of doing all those things. The other 4 documents that I like to talk to people about, those are living documents.
Okay.
These are a world in where you are still alive, but decisions need to be made and life needs to move forward. The first 2 I'm going to talk about of those 4 living documents are companion documents. They're durable powers of attorney. I do one durable power of attorney for financial decisions, and I do one durable power of attorney for medical decisions.
Okay.
And these are the documents, they live while you live and they die when you die. But these are the documents that allow somebody else to step into your shoes and make decisions for you should you need it. When we have a spouse, that's our number one person. But we've got to have those backup people lined up because, again, God forbid you're in a car accident and both spouses are in the hospital. We've got to have legal documentation lined up so that somebody else can step in and keep things moving forward, keep making decisions, paying bills, taking care of the kids, whatever tasks may need to be done. I tell people durable powers of attorney are probably the most important documents I do, in my opinion, on a daily basis because they're the ones I see the most troubles with if people don't have them in place or they're not done properly. These are so important to me that the day my children turned 18, I had them sign durable powers of
Oh,
attorney
really? Okay.
because they are now legal adults. And even though I am their parent, I don't have any legal authority to make decisions for them without legal documentation. Now, we do have some emergency laws that say, okay, if you don't have a durable power of attorney for health care, then we're going to talk to your next of kin. The problem is you may not like your next of kin, or your next of kin may not be who you would want them to turn to for
Right.
those medical decisions. We don't have a similar law for financial decisions. So if you don't have durable power of attorney for financial management, the only solution for your loved ones is to have to go get court appointed guardianship over you. I do have some clients that resist them because they feel like they're somehow giving up power by doing them. And I actually like to say you're actually doing the opposite. This is the ultimate exercise of authority because you are putting in a document who you trust wholeheartedly with access to all of your assets and all of your medical information. And I tell people if you don't do that, you're actually going to lose authority because then the state's going to decide for you. And you may not like who they pick. You're better off having that authority. Now, the other thing is a misnomer about durable powers of attorney is that they can be used to override your decisions. That is not true. Durable powers of attorney can never be used to override somebody's decisions.
Wow.
They
Okay.
can
Good.
only be used to help people. And your agent has a fiduciary duty to you, either exactly what you ask them to do or what they think you would want them to do. They're not supposed to replace their own wants and opinions in there. Now, does that always happen? No. But that's why we pick people we trust because the people we trust are going to try really hard to honor our wishes.
Exactly. If
So,
I could jump in, Danielle, one thing I look at when I work with a client, I ask for their estate planning documents. I read them through just to make sure the whole agrees with what I understand their wishes are. And one of the things I commonly see with their powers of attorney is a difference between whether it's effective immediately or
yes.
upon their incapacitation, which usually means they need to have two physicians
Yeah.
say, hey, you can't handle yourself. So and so is
Yeah.
now your power of attorney. What is your
Yes.
take?
I'm pretty opinionated on this one, and I'm really glad you brought it up because
Okay.
historically, yes, durable powers of attorney were what we called springing. They
Yes.
would only spring into action if you were deemed incapacitated or unable to manage your affairs, which would require a letter from a doctor or
Hmm.
two doctors.
Hmm.
But that's become so problematic that almost no attorney does it that way anymore, because there's three main problems with that. Number one, we all know capacity is not black or white. It
Yes.
can do this.
Yes.
So even trying to capture somebody, get them to a doctor. I've had clients who trying to get those letters and they take their parent with dementia to the doctor and their parent does really well that day. And so they're unable to capture that incapacity moment. Number two, doctors don't want to write these letters anymore at all. They don't like it. They don't like the liability of it. It makes them nervous. And three, even if you could find a doctor willing to write a letter, good luck in an emergency getting in touch with a doctor who's going to sit down in their busy day and write you a letter so that you can do what you need to do. So it's
Exactly.
just become so impractical that we now have them effective immediately when you sign them. So the next question I get from clients is like, oh my gosh, Danielle, doesn't that mean that my kid that I've just named in the document could go to my bank account and wipe me out? And I say, it absolutely means he could do that. If you don't trust him not to do that, don't put him in your document. And that's why it is really important. We only put people that we truly trust, which I know can be a challenge sometimes.
I'm so
So,
glad you said that because it seems like more often than not, I do see the POA
yeah,
upon contingency. And I say to a client, look at this line item. You get no help from this person until, under the best of circumstances, like you said, which are
yes,
hard to come by, you get one or two physicians to say, okay, now this person has the keys and now they can
yeah,
help you. And I would just think if I were that person, even if I understood what was going on, how uncomfortable to feel like I'm voluntarily saying, I can't take care of myself. That's one
yeah,
of the last
yeah,
things that people want to do in their senior years is
yeah,
relieve themselves of their dignity. So I'm glad you bring that up. And completely, that's the whole reason I emphasize with clients: review your beneficiaries, review your personal
yeah,
representatives, executors, powers of attorney regularly, so you make sure you still feel good about those decisions, because
yeah.
otherwise it could be more harm than good.
And these are the ones I'm most frequently updating, these documents. Oftentimes, I can look through somebody's previous documents and their will is still valid and great. Nothing's changed. And their other documents are great that I'm going to talk about in a minute. But the durable powers of attorney are the ones that are, to me, we're creating them for the benefit of a third party, such as yourself, to honor that person's agency. I almost always recommend updating durable powers of attorney because these have become so important in today's world, and anybody 18 years or older should have them.
I agree with you. It's the perhaps the most underrated estate planning document. I'm glad you made that distinction between the dead document for when you're dead, and all the rest of these are very relevant, in fact, imperative before you're passing. On my side, on the financial advisory side, investment management side, it's very common that, hey, I'm the son, whether I know them or not yet already, and I'm here to help get the money out or make a change or whatnot. And I say, great, I'd love to help. Can you get me the copy of the power of attorney? If they say, I don't know if I have one of those, I say, I'm so sorry, but I cannot. I will not help you unless I can talk directly to the account owner, which isn't always a viable option, or I need to get a
Right.
durable power of attorney on file. And then, yes, then I can freely, I want to help the client and their family, but my hands are tied, right? Until I have that
Exactly.
document.
Yeah,
Exactly.
you brought up a good point. Part of the problem is you have to have capacity to sign these documents. You have to be able to understand when you're signing durable powers of attorney. So if we wait until we don't have the capacity anymore, maybe it's dementia or some sort of cognitive issue, we can't sign them now. And so then your family's only option is to seek court appointed guardianship over you to make your decisions. And you want to talk about an expensive, timely process. It's not worth it. These documents are so accessible. So you don't even have to go to an attorney for them. I did say earlier that these durable powers of attorney live while you live and they die when you die. The one exception to that rule is there's one power that survives your death, and that is that your healthcare agent is allowed to deal with your body. Whoever you've named in there can take that document to a funeral home and they will honor that person's authority.
I hadn't even
Yeah.
thought of that. That's a great point to add. Thank you.
The third living document, if you will, it goes by several names. I call it a healthcare directive. It's also known as an advance directive or a living will.
Okay.
I don't love the living will one because that confuses people. This is where you get to put in a legal document whether you would want to be kept alive artificially at the end of life or not. This document only comes into play if you are either in a permanent unconscious condition, two physicians have signed off and said that you're never going to regain consciousness, and the only way they can keep you alive is artificially, or if you're so terminal is 6 months or less to live, your death is imminent, and the only way they can prolong that process is artificially with machines, whether you would want to be kept alive or not.
Mm.
And 99% of my clients, the answer is no. But I will say this document serves several important purposes. One, anytime you even go in for a minor procedure, they are always asking patients if they have advanced directives. Number two, it answers that question for your loved ones. So it alleviates them from having to make that decision if faced with those specific circumstances.
Right.
And three, it also cuts down on disputes. If we've got family members who one says, pull the plug, and the other one says, no, keep her alive at all costs. We have a legally enforceable document that says what the person's wishes are. Probably one of the biggest misnomers is people are like, I already have one of those. I have a DNR, so I don't think I need this. And that is a different document. A DNR in Washington, we call that a POLST. It's a bright green sheet that you get from your doctor, and it is actually a medical document. And it is really historically a do not resuscitate. And they tell my senior clients, put it up on your refrigerator so that if the emergency personnel bust into your house, they know whether you want CPR or not.
Sure.
And for most healthy-ish people, the answer is yes. They want them to at least try, right? They want them to give it a good go and then get them to the hospital and stuff and then see how things are. To me, that is a different document. That is an emergency-oriented document. The document that I do, imagine you are already in the hospital. You are already hooked up to machines. It's just a matter of your family deciding whether it's time to end that. My document is that you're at the end of life. There is no doubt. That's a distinct difference there.
I can just imagine how much more peace of mind it gives when they have that document because they no longer are a decision maker. I think that's one of the worst things I can imagine is my parents on their deathbed and I'm the one deciding whether they live or die. It's like a godsend to say that here's a document in their own words.
Yeah.
No matter what me and the siblings and the family thinks, look, this is the order and I'm not the decision maker. Don't kill the messenger. And so you want to talk about a way to save your family grief in addition to preparing a will and dividing assets. It's that crucial end of life phase to say, no, this is what mom wanted. So no questions asked.
Yeah, absolutely. It does serve an important purpose. And I always tell people, though, if they do opt not to get one, whether it's because they don't want to think about it or cost or whatever, I say make sure to at least tell them as much information as you can, because ultimately they're going to be the ones the doctors turn to make that final decision. But if you have the document already telling them their decision, of course, it makes it easier. And then the very last document that I often do for people is just a simple HIPAA authorization. What we're running into is medical providers are cracking down on HIPAA laws more and being less willing to share our medical information with people. So what can happen is a loved one can end up in the hospital, and unless you're on some pre-authorized list, there's a good chance if your spouse wants to call, they're not going to have a problem. But say your kids want to call or your parents want to call, they're going to probably be told, nope, sorry, we can't even tell you if that person's a patient here. And HIPAA laws prevent us from being able to share that person's private medical information. Gotcha. So I can literally just create a list ahead of time of all the people that you would want to be able to get access to your medical information. It's not a decision-making document. They're not weighing in on your health decisions. It's just who you'd want to be able to call. So for example, I'd want my spouse and probably my kids and my parents. That's the basics of what we estate planning attorneys usually offer. And like I said, people shouldn't feel pressured to walk in and have to buy an entire set of documents if they don't want to. I guess it depends on the attorney and how they present the information, but depends. I know, the infamous depends.
No, that's really insightful. So to round out, just so I can recap for the audience, those 5 documents, and maybe you'll need to just take over for me, but the first is that will/trust document. Next is the durable power of attorney for healthcare needs. Next is the durable power of attorney for financial needs. And the next is and I'm just remembering the 5th one, but the 4th one.
Healthcare directive.
Healthcare directive for that end of life decision making. And then the 5th is that HIPAA authorization. So no, that's super insightful. I really like that in your process. It's very education oriented. So in that first conversation, whether it's in person or over the phone with you, clients get a really good grasp of what direction they should be considering, what they do need, what they don't need, and make an educated, informed decision, not only about working with you, but what they actually need. And for that reason
Yeah.
alone, I feel really confident and get great feedback from clients of mine that I send your way. So I appreciate taking care of our clients because their retirement plan isn't complete without
Mhm.
these documents that you just cited. So really appreciate
Yeah.
that.
Yeah, absolutely. It's a team effort because, what you do and what I do and what other service providers do, it's all connected. We all share the same clients. And it's good when we can do that tag team work and figure out how to get them exactly where they need to be so that they don't have to worry about this stuff.
Definitely. If people are looking for an accessible attorney to work with, you're looking at her. So
Yeah.
really
Yeah.
appreciate your insights and feedback. And for those that are interested in continuing the conversation with you, I'll put your contact information in the description of this video below so they can reach out to you.
Yeah.
Well, Danielle, I
Yeah.
really appreciate your time, your expertise, your insight. I
Absolutely.
know I learned some things today, so I know the
Yeah.
audience did as well. So I really appreciate it. Thank you.
And thank you for having me. I love these opportunities. I love working with partners on this stuff and the education piece. I think we both agree on that. So thank you for having me and giving me an opportunity to share this information.
Of course. Pleasure.